As of whenever your appointment date was, you are considered the personal representative now for the estate. That's the same thing as being someone's executor. That tends to be a term that we are more familiar with. But in South Carolina, our law calls you the personal representative. As the personal representative, you are considered what the law calls a fiduciary. And you have the responsibility to look out for everyone's best interest who is involved in the estate. Not just yourself, but everyone involved in the estate. And you must follow all state laws pertaining to estate administration. Now, in the mail, you should have received from us a few things that show that you are now the personal representative. So the first thing that you've got is your fiduciary letters. So this document typically is just for your records, and it is going to show that you are the personal representative for the estate. Similar to the fiduciary letters, you're going to have your certificate of appointment. You probably received 3 of those in the mail. Your certificate of appointment shows that you have been appointed the personal representative for the estate, and you'll also see on the bottom my signature as well as the raised seal of the court that you can feel with your fingers. That is the document that you will need to take with you when you are conducting any business on behalf of the estate. So if you need to go to the Department of Motor Vehicles and obtain a title or change a title, or if you need to go to the bank and open or close a bank account, or if you need to do anything else where you have to prove that you're the personal representative, you need to take that with you. We've given you 3 of them because sometimes you might have to do some business by mail. That way, if you don't get it back, you'll have a few backup copies of your certificate. If you ever need additional certificates while the estate is open, just contact our office and we will be glad to supply those to you. The other thing that I wanted to go ahead and discuss with you is a document that we require that all of our personal representatives complete, and that's called the affidavit of personal representative. You should have that in your possession, and we're going to go through it together just so you have an understanding of some of the general responsibilities of a personal representative. It may be that some of these items don't pertain to your particular estate that you're working on, but this is just meant to be a general overview. So we'll start up at the top of the document. Please note that this is a sworn document. The assets and money of the estate are only to be used to pay the debts and obligations of the estate in their order of priority. So what you're doing as personal representative is you are collecting whatever the person owned, and you are holding those items until it's time to close out the estate. In the meantime, you can use the assets of the estate to take care of the debts and obligations of the estate. For example, perhaps there was a funeral bill that needs to be paid, or some other type of bill. But you don't want to go ahead and give out the assets to the individuals to whom they are ultimately going to. You need to take care of the obligations of the estate before you begin giving assets out to the people that they go to. Secondly, if there is money involved in the estate, so let's say your loved one had a bank account that was in their name by themselves, or perhaps there was an insurance policy that was payable to the estate and you've got a check payable to the estate or payable to your loved one, those monies need to be put into a special estate bank account. So you would take your certificate of appointment, go to the bank of your choice, and open an estate bank account. The money of the estate would all be put into that account, and then you could easily pay out any debts and obligations from that account, and it will be easy to show what you've done with the estate funds because you will have to account to all other interested parties. Next, I'm not to use any estate assets or monies for my personal debts or obligations, and also relatedly, I'm not to use estate monies or assets for the debts or obligations of any heir or devotee. So basically, If someone comes to you and says, hey, I'm a little short on my mortgage this month, can you go ahead and just give me my money out of the estate? Your answer should be no. You've got to take care of the estate debts and obligations before you give out money to those to whom it goes to, and you certainly should not be using any of the assets of the estate for your personal bills. So if you're a little short on a bill that you owe, do not dip into the estate money because you will be responsible for that. And you'll hear as we go along the terms heirs and devisees. So heirs, by the way, are people who receive assets if there's not a will. Devisees are those people who receive assets if there is a will. Next on the affidavit, you have two provisions that have to do with selling things. So oftentimes during an estate, it becomes necessary or appropriate to sell some of the assets of the estate. If you need to sell an item of personal property, for example, a car, first we're going to find out how much is it worth. If it is worth less than $10,000, you may sell without a court order. If it is worth more $10,000 or more, either you need to have that person's will that says you have permission to sell things, or you will need an order of this court. So you would need to submit an application that we would be happy to provide to you, and then the court can lead you from there as to your responsibilities with selling things. Now with real estate, it's treated differently. For real estate of any value, either you need to have a will of your loved one that says you can sell that real estate, or you have to petition the court for a court order to sell the real estate. If that is something that is necessary during estate administration, please contact the court or an attorney of your choice so that they can lead you through the process. Next on our affidavit, which we've already talked about, I must resolve the debts of the estate before making distributions to heirs or devisees. This is very important. Next, we start talking about claims, and we're going to talk more in a separate video about dealing with creditor claims. But just know for the purpose of this affidavit that you are responsible for responding to creditors' claims in a specified time period. And that time period is 60 days after the presentment of the claim, or 14 months from the date of your loved one's death, whichever is later. During that time period, you must respond to creditors in writing. Finally, on the affidavit, I will be personally liable, that means you're personally responsible, to any beneficiary or other person having an interest in the estate for any negligence or intentional misconduct in the performance of duties as personal representative. So please be careful as to how you administer estates. Make sure that you keep up with your records so that people can easily see how you've handled the assets of the estates and you can keep yourself out of trouble.